Hi, and welcome to another episode of Coffee Break. I'm Nathan Willner, Vice President of NCBA, and I'm excited to have with me today Pete Nanov, who I know for quite a while, but is a new NCBA member. So just excited to hear about you, what you've been up to, and your journey into this industry, and how you're doing today. So welcome to Coffee Break, Pete.
Thanks very much, Nathan. Happy to be here.
Okay, well, tell our audience a little bit about yourself, where you went to law school, what kind of law you practice, and how you got into this industry.
Sure. So currently I'm a counsel attorney at the law firm of Saul Ewing, doing complex commercial civil litigation and consumer financial defense work. I went to law school at William and Mary, and shortly I got into the debt collection world pretty much right out of law school. At the time, I was looking for prosecutor jobs or civil litigation jobs that would give me a lot of courtroom experience right out of law school. And I ended up applying for and started working for a boutique debt collection firm in Rockville, Maryland.
Yeah, that's great because I don't know if you've heard, but NCBA has been working on a law school outreach initiative, and part of what we talk about is folks that are interested in working like in district attorney or state's attorney's offices or public defender's offices because they want to get the courtroom experience. I don't think there's any field that gets you more courtroom experience quicker than uh, debt collection litigation.
Oh, absolutely. I mean, I was a courtroom nerd. I did mock trial in high school, college, and law school. And when I, during my interview and what I eventually, with the firm that I ended up working for, is I was in court all the time and I was trying cases very, very early on. I was arguing motions very early on. And I was given a lot of really interesting assignments, even to do some appellate work when it arose in the debt collection world. So yeah, for me, it was a great opportunity to get a lot of that courtroom experience right off the bat that I was looking for.
So how did you get from doing the in the trenches kind of debt collection litigation to working in big law? Saul Ewing is a large law firm, very well known. How'd you make that transition, and was it difficult?
The transition was over a few years, and it started actually at my first job at my boutique collection firm. Some of our clients were interested in having someone handle their defense work that was arising out of the collection work. And there are some collection firms that send that defense work out, and I voiced an interest in doing that type of work. And got to know, obviously, I was already familiar with a lot of the laws that regulated the debt collection world, having operated as a debt collection attorney. And so transitioning and taking on that defense work as well wasn't all that difficult. And then from my experience in the courtroom in Maryland, a boutique, well, not necessarily a boutique, a smaller Virginia firm, about 35 lawyers, was looking to open their first satellite office outside of Richmond. And so they were looking for someone with a lot of Maryland experience to help teach their partner that they were sending from Richmond to the DC area about Maryland procedure and someone with familiarity with the Maryland courts. So they ended up hiring me to provide that experience.
And you're licensed in several states, is that correct?
Uh, yes, DC, Maryland, and Virginia.
So you're familiar with, courtroom procedures and processes in multiple jurisdictions and different, whether it be small claims court or, general trial court or appellate court. So you've seen it all, right? You've seen the good, the bad, and the ugly. So I assume at this point you're working mostly doing regulatory kind of work and defending claims against different kinds of debt collectors and those kinds of issues. Is that primarily what you're focusing on now?
Yes, since transitioning to the Virginia firm, I have now this is my fourth law firm that I've worked for at Saul Ewing, and since I made the move away from the debt collection firm, I have been primarily focused on defense civil litigation. And most of the clients that I defend in this world are banks, credit unions, and some debt collectors, some property management companies, things like that, as well as a broader consumer protection defense practice.
So, I mean, the FDCPA has been around for a minute, and pretty clear who and who is not regulated, I would guess. Any cases that you worked on that were, out of the ordinary or unique when it comes to talking about the FDCPA or Reg F and the CFPB?
Yeah, well, it's interesting you mentioned that, you would think it's clear who it applies to, but it's really not. I actually had a case back in 2017 that involved a claim of an FDCPA claims against a property management company. And there is a little known part of the FDCPA that excludes from the definition of debt collector any person collecting or attempting to collect a debt that is incidental to a bona fide fiduciary obligation. And so in our case, we had a property management company that, in addition to collecting debts on behalf of the HOA that had enlisted it, it also engaged in a lot of other fiduciary duties and fiduciary obligations on behalf of this HOA. And we made the argument that the FDCPA did not apply to the property management company because its collection activity was only incidental. And ultimately, the court ruled in our favor because we were able to show all kinds of different other fiduciary obligations that we were fulfilling or that this property management company was fulfilling on behalf of the HOA.
That's fascinating, and I don't see many cases like that out there. I just don't see that argument being made. So that really is fascinating, that where something would, appear to be collecting a debt on behalf of a third party in that scenario was not, didn't fall within the definition that most people think is the standard for debt collection regulations. So it's interesting. A homeowners association, not a debt collector. Lawyers are debt collectors. So we need to work on that, I think, because that would definitely seem to infringe upon the independence of the practice of law.
Yeah, well, it's interesting. I mean, obviously, lawyers owe a fiduciary obligation to their clients, and the question is whether I don't think I've ever seen this litigated with respect to a law firm. I can tell you that the case I worked on was an issue of first impression in the Fourth Circuit. We primarily relied upon and cited a decision from the 11th Circuit with respect to property management companies. But obviously, like I said, lawyers owe that same breadth of fiduciary duty and obligation to their clients. The question is, the incidentalness of their debt collection work versus any other service that they may provide for that client.
Yeah, no, that's really interesting, and it might be, case by case, because there might be some law firms that do everything for a client, some just do, this piece of the work. So it's really interesting. But NCBA is working on changing the law, so hopefully we will be successful in that regard. But again, it isn't difficult to find scenarios where serving multiple masters, having a regulatory scheme, and your regular model rules of professional conduct kind of contradict each other, or put on obligations that make it impossible to completely fulfill one over the other. So yeah, that is an issue that we're looking at. So anyway, Pete, I know you just gave a webinar at NCBA about the CFPB. Are you finding that, because it appears for the moment the CFPB has kind of curtailed its enforcement activity, do you think there's going to be less issues across the country? Or are there any other regulators you think we need to keep an eye on?
Well, it seems pretty clear that the CFPB is pulling back its regulatory enforcement activity, but I think we can certainly expect state level entities increase their enforcement activity. And some states, particularly New York and California, have already signaled, and I mentioned this in the webinar, that they are interested in hiring displaced CFPB employees. So they are very obviously interested in gearing up and fulfilling any gaps left in the enforcement world that is left by the CFPB's pullback. And I think that you'll continue to see that across more active state regulatory authorities across the country, particularly, and not to get too much into politics here, but as blue states may try to flex their muscle or challenge some of the activities and challenge the pullback of the Trump administration.
Yeah, so this is probably the last, not the greatest time to abandon some of the safeguards or some of the regulatory, procedures that you may have put in place at your firm, because, first of all, the pendulum swings, but if it hasn't affected your firm negatively till now, probably good, practice to keep those things in place. And as an industry, we constantly are talking about we self-regulate and self-police, try to weed out bad actors. So again, here's that moment in time where we need to stay completely, transparent and compliant, and make sure that we don't only talk the talk but walk the walk. So but anyway, thank you so much for coming on Coffee Break with me and talking about your journey into this really exciting legal practice that people kind of overlook when they're in law school, and it's just really robust. There isn't one area of law that is not touched by the work that we do, whether it be constitutional law, regulatory law, administrative law, bankruptcy law, courtroom procedure, and on and on. And the list goes on and on when it comes to this area of law. So in closing, you're a new member of NCBA. I'm sure you're familiar with NCBA. I know you were involved in the Maryland DC Creditors Bar Association back in the day. So what made you want to join NCBA now? I kind of put you on the spot, aren't I?
Well, it's just an industry that I've been keeping tabs on for many years. I've continued to work as I said, I've continued to work on the defense side of this industry, even since I left the actual practice of debt collection. And so it's an area that I decided that I wanted to become more plugged into as my practice in this area has continued to grow. And so I thought it just made sense to be more familiar and with everyone on the ground and what they're experiencing, and maintain the same level of understanding that I had when I was those same individuals on the ground.
Yeah. So thanks, Pete. And we are the go-to for this industry, and we're really excited to have you be part of NCBA. And you've already started to give back and help your colleagues. So we're really appreciative of it. And hopefully you're going to come back on another episode of Coffee Break, and we'll talk a little bit more about how things are going and what's next on your agenda. And I also understand you're going to be coming to NCBA's Connect conference, so we're excited about that, and hopefully you'll be a presenter there as well. So with that, have a great rest of your day, and thanking our listeners for tuning in, and enjoy your cup of coffee, and we will see you on the next episode. So thanks.